certain laws which apply exclusively to children. And before I do that, let me ask you a few basic questions, only in order to gauge your level of understanding, of course, or what you have experienced, what you have seen, whether that is real or something which is purely imaginary. The people from third semester as well? Third semester?
Yes, sir.
Yeah, many. Yeah, good. Incidentally, only today or for the last 2 days, for that matter, I've been talking about Juvenile Justice Act of 2000. Now when I teach criminal law and I'm discussing principles of criminal law, you should ask this question, that why Juvenile Justice Act of 2000 and why reference to other laws as well. Are there first year people as well? Many?
Yes, sir.
First years, okay. Okay. Those who are in third semester and onwards, of course, they are aware. They are aware that IPC, CRPC, Evidence Act, that is hugely oriented towards what we call adult criminal justice system. It is presumed that all crimes are committed only by adult people, adults who have developed sufficient maturity. But I think media has made you believe that if crimes are being committed in this country, most crimes are being committed only by those people who are in that age bracket of 16 to 18 years. Now I think you might also be knowing that media even demonized one juvenile who was involved in that ghastly Delhi rape case of December 2012. Now, why we need a law which treats children differently, and who do we call a child? These are few basic things which you need to understand before I talk about provisions and more provisions and even more provisions on juvenile justice law. So this is for first years, not for third semesters and onwards. Who is the child? Who is the child? This is only for the first years, please. Who is a child? Is that difficult a question? Who is a child? And what is that criteria? What is that criteria? Is that inquiry subjective or objective? Meaning thereby, would you consider a person child only if he has no sufficient maturity of understanding? But then you have wonder kids. I was telling people that you have wonder kids appearing every day, almost every day, on electronic TV channels, reciting Bible, Quran, Gita, answering all questions which even we may find very difficult to answer, knowing all the facts and figures in this entire world. So who is a child? Who is a child? You need not seek my permission before you answer that question.
Sir, if we consider about definition of child, so it depends according to the subject we are talking about.
Okay.
If we consider as a life, that when
As a?
For life, that when a person attains life, so a child is someone who has attained viability, the age of viability.
That's something which is very, I think, very beginning.
Yes.
I'm talking about the threshold of that. That when a person would be a child up to what age?
So up
to what age?
18 years.
Which year?
18 years.
18 years. 1/6. Why this 16? How this figure came to your mind? Which amendment? Juvenile Justice Amendment.
Sir, it was said that in heinous crimes, the age limit can be considered from 18 to 16.
Downwards, huh? 18 to 16 or 16 to 18. Any other age which you consider is the age of a child, or the threshold when a person would be deemed to be a child, considered to be a child? It's 18 years, period. All your notions which you carry, that for heinous crimes it would be 16 to 18 years, or 3 years, or viability, or all these are all extraneous considerations. After 2000, when this new jurisprudence, child rights jurisprudence was ushered in, the age of juvenility or a child is anyone who is below the age of 18 years. 18 years. There is no subjective inquiry. No subjective inquiry in the sense that it would not be inquired whether he has developed sufficient maturity, understanding, whether he understands the nature of the act or its consequences, whether he is able to distinguish between good and evil. All these are extraneous considerations. When the law declared everyone who is below the age of 18 years to be a child, you can take it for granted that a child would always be a person who has not completed the age of 18 years. Now, what you are talking about, that is only in the pipeline. Only in the pipeline, in the sense that the law has not yet been passed. That Amendment Act of 2014, the Juvenile Justice Act of 2000 would be replaced, if that law sees the light of the day, of course, that would be replaced by the act of the same name, Juvenile Justice Act of 2014. But even that does not change the age of a child. Let me make it very clear that the definition of child would remain intact even under the new law, if that sees the light of the day. And the age criteria which you are talking about, 16 to 18 years, is only for certain purposes of prosecution and punishment. Prosecution and punishment. But that cardinal principle, that rule, that everyone who is below the age of 18 years deserves some differential treatment different from the treatment which is meted out to the adult people by the stakeholders of criminal justice system, that remains intact even under the amended law, if that happens. Now, for the purposes of our discussion, let me also ask you that what role do you visualize for a paralegal in the juvenile justice system? This is not a regular class where I am supposed to teach you each and every provision of Juvenile Justice Act, or for that matter other child-centric law. I must make sense, and you should also be only interested in those aspects of JJ Act, for that matter other legislations which are of immense importance for paralegals. Or if you say, for example, if you have volunteered for legal aid, what do you think you can do? Do you have some idea, some vague idea, some imaginary ideas, or something which you believe that you can do? But let me think that whether that is permissible, whether that is possible, or what role you can play as far as your enthusiasm is concerned. You all can play a role, very, very significant role, but you must also know the limitations. You can't be a substitute for the professionals. You can't be a substitute for the professionals who have been named there, meaning thereby you can't take the job of member of the Juvenile Justice Board unless and until you are nominated, unless and until you become a judge, or unless and until you are nominated or selected by the state government. You cannot even take the role of what we call a special juvenile police unit. You cannot take the role of probationary officer. You cannot take the role of a child welfare officer. And also you are not an NGO. Specific roles might be assigned to the NGOs. You are not even an NGO. You are working with a government institution. This university is not an NGO. So, what do you think? That could be your role?
Assisting those.
Assisting.
Yes.
Assisting whom?
So the NGOs.
NGOs, okay. And?
We had a connection between the person who will be coming to us and these NGOs, officers, probationary officers and all these. We are the link.
Okay. Okay. I doubt that any juvenile who is in need of care and protection or who is in conflict with law would ever approach you. I doubt. No. They are so scared people that you need to find them. It's not that they would be finding you. If you are sitting in your office there, in your legal aid clinic waiting for juveniles in conflict with law or juveniles who are in need of care and protection coming to you and asking for some kind of legal aid, I think you are mistaken. You are living in some different world altogether. No, that's not going to happen. That's not going to happen. Those who come from influential family, they would not be children in need of care and protection. They would only be delinquent children. Delinquent in the sense that children whom we call children who are in conflict with law, juveniles who are in conflict with law. And if they come from influential family, of course, they would be approaching some high-profile lawyer, not you, for seeking some kind of legal aid. Those who are really in need of care and protection, they would not be coming to you. Scared, of course. Scared. Scared. Those who may be in conflict with law, they would also not be coming to you. They won't be coming to you. Before they would come to you, they would be picked up by the police. And they would be hauled up in some police station, in some lockup. So it's you who has to look for them. Are there people who are in need of care and protection, who are below the age of 18 years? And also you need to see whether people who are in conflict with law, when I use the term people, I only refer to the children who are below the age of 18 years. Are they being treated the way they are supposed to be treated under the letter and the spirit of JJ Act of 2000 and also the JJ Rule of 2007? It has been almost 15 years. Law was passed in 2000, we are talking about that law in 2015. 2015, we are only concerned, I was talking about this aspect, this problem in the class today itself, that we are only concerned about half of the people who are covered under that JJ Act of 2000. Everyone is concerned only about juvenile in conflict with law. Every opinion, whether that is to raise the age of juvenility or to decrease that age of juvenility, revolves around children who are in conflict with law. As if the entire criminal problem or the problem of crime in this country is created by these juveniles. That's not true. That's not true. And you are also supposed to cross-check your facts and figures. Every year, NCRB, that National Crime Records Bureau, it releases data of crime in this country every year. Meaning thereby the data for 2014 is now out. And it's for everyone to see. Those who believe that juvenile criminality is on alarming rise, they are wrong. Completely wrong. Completely wrong. Juvenile criminality is on a rise. There is no doubt. But the reason is not because juveniles are now maturing early. That is not the reason. The reason is that the system neglected those juveniles who were really in need of care and protection. And there is a link. You have to understand that link. A child who really needs care and protection, if neglected, would ultimately become a child in conflict with law. There is no research required for that. Everyone knows this. Everyone knows this. So, blaming those children who are in conflict with law, that they are demons, they don't deserve a dignified life, they should be hanged, they should be treated like adults, is shunning your responsibility. Responsibility which is shared by the society, responsibility which is shared by the state, responsibility which is shared by the civil society, by people like you and me, by other institutions. So unless and until you understand that how that system works, for the benefit of children who really need care and protection, of course, you would not be able to understand that why children in the age group of 16 to 18 years or even lesser indulge in many heinous crimes. And then let me also tell you one conflict of interest which you are going to experience once you graduate from this law school. If you take up this criminal law practice, you would be approached only by delinquent juveniles or their parents. For what? For defending them. Is that wrong? That's not wrong, of course. You need to defend them. Every criminal, even if adult, even if he is caught red-handed on camera, must be defended by the best lawyers. I often cite that example of Ajmal Kasab. How did we treat him? He was given the best legal service in this country. Best. Even at the apex level. The best lawyers of this country, they defended him or argued for lesser punishment with the Supreme Court. The real conflict would arise when you would be approached by those who have crossed that age of 18 years. 18 years. Enter that 19 years, that twilight zone. They are not adults in the strict sense of the term, but they are no more juvenile. They are not child. And they would only require you to prove by hook or by crook that they were juveniles when they committed that crime. You're getting my point? I have spoken to several of your alumni. They told me this. They told me this. They even asked me that how can we do this? How can we do this? Once you are successful in doing that, you are betraying the whole criminal justice system concerning children. Maybe you might be paid very handsomely for doing that, and that lure may be fatal. That may be very attractive. I understand. But if you take one single such case where the ample evidences to suggest that the person was not a juvenile on the date when he committed that crime, you are doing an injustice to whatever you learnt here. Now that would not mean that he should not be defended. Are you getting my point? I am not declaring him a criminal. I am not. But this beneficial legislation is reserved for certain people whom we call a child. If fake children means those who are not really children but they want a proof by hook or by crook that they should be treated as children. If they are treated as children by the system, of course, that would be a very sad day for the whole criminal justice system, whole juvenile justice system. So this is one conflict which you are going to, I think, face once you graduate. There is not much, let me tell you, there is not much which you can do except that imbibing certain values which the Juvenile Justice Act of 2000 and Juvenile Justice Rules of 2007 want everyone to imbibe. Values are that every child should be treated with care and protection. Even if the child is in conflict with law. A child would not be committing a crime if he is properly cared for. I don't believe that pampered children or children who are treated very well, very fairly by their parents, they often are stubborn and they often indulge in certain activities that everyone would do. Everyone would do, of course. Everyone would do. And every delinquency is not fatal. Every delinquency which is shown is no sign that the person is going to become a hardened criminal in future, of course. Certain delinquencies are inevitable. Inevitable. So many things which I did when I was a kid, when I was a teenager, I cannot even imagine today doing. So many things. And you would be laughing when you would remember those things which you did as a child, as a teenager, as someone who is very young. Very young. You don't care for the consequences. You don't care. I did not care for the consequences, but I care for consequences today. So many things which you won't imagine. Won't imagine. Doing once you become adult. And only because someone has competed in CLAT and has secured admission in some law school, he must have some very mature understanding. Someone who has topped IIT or someone has secured admission through CPMT or CBSE in some very prestigious medical college, or someone has won some scholarship is no criteria to gauge whether he has sufficient maturity of understanding or not. Ability to solve a very difficult mathematical problem is entirely different from taking a rational decision. Rational decision, that ability to take a rational decision would only come with experience and time. You are not expected to take those rational decisions which I can take very easily. And for that you need some extra care, some counseling, and at times some pep talk as well. And that is exactly the very idea of the whole juvenile justice system. Pep talk, admonition. If that is ineffective, you would be required to do some community service, something like that. Even if that is not sufficient, of course, some more severe kind of punishment would be wrong, but some different treatments altogether. So Juvenile Justice Act of 2000 is one piece of legislation which I believe there are problems in every law. But Juvenile Justice Act of 2000, the rules which have been framed thereunder, they are the example of best laws which we have in this country. Best laws. Very well researched, very well thought of, and the problem is only in the implementation. The very reasons in the sense that we have taken the entire justice system for granted. We believe that if my child is in trouble, of course, I would be able to see that he is not troubled. He is not troubled. When you have this understanding of the system, that you can do whatever you want, if it is about your child, of course, only God can save this system. And unfortunately, that is the sense which is prevailing in this country. I was also telling, we love children. We all love. But only when children are our own. When it comes to loving children of others, of course, we are. So this is the problem. And also, the problem is that there is an utter lack of political will. No government appears to be concerned about the rehabilitation, aftercare. What would happen? Once a juvenile who serves his sentence is released, what would happen to him? He would be stigmatized, he would not be integrated in the mainstream of the society, he would not be able to gain some employment, He would not be treated at par with other people in the society. He would be carrying that stigma all his life. So the things which you can do as a paralegal, as a volunteer, as someone who is really interested in the welfare of children, which you all were only two years back or 3 years back, of course, is to imbibe certain values. That is the first thing, imbibe certain values. Imbibing those values would not be that difficult for you. It won't be difficult for you. It would be difficult for those professionals in adult criminal justice system who are, I already told you, who are trained in IPC, who are trained in CRPC, who are trained in Indian Evidence Act. IPC, CRPC, Indian Evidence Act has no relevance when it comes to treating a child. Whether that child is in conflict with law or is in need of care and protection. Forget all these. Unlearn what you learned as far as IPC is concerned, CRPC is concerned, or Indian Evidence Act is concerned. If you still carry that baggage of CRPC, IPC and Indian Evidence Act, you would never be doing justice to the letter and the spirit of Juvenile Justice Act of 2000, or for that matter the JJ Act of 2000, the JJ Bill of 2007. So that is one initial step which you must all take, the very beginning. Unlearn the biases, unlearn those biases which you carry when you see or when you come across a story of a delinquent juvenile. He is not an accused. He is not an accused. I told this in today's class that there is a strict prohibition of certain words. Words which shall stigmatize a child. Stigmatizing semantics are completely prohibited. Completely prohibited. Meaning thereby, the terms which you often use when you talk about an accused who is adult and is treated under the adult criminal justice system are a strict no when it comes to a child who is under the age of 18 years. So there is no arrest. If he has to be detained, the word which is used there is apprehension. Apprehension. Now you may say that how that is going to make a difference, but that would make a huge difference. Let me tell you, huge difference. Huge difference. There is no charge sheet. There is no charge sheeting. There is no trial. There is no accusation. There is no examination in chief. There is no cross-examination. There is no examination of the accused. And there is no accused at all. There is no accused. There is no prosecution either. There is no punishment as well. Punishment. The word punishment, the word arrest, the word trial, the word charge sheet. These words are alien to the Juvenile Justice Act of 2000 or the rules of 2007. So omitting these words in your parlance, from your parlance, when you talk about child rights, when you talk about juveniles in conflict with law, when you talk about juveniles who are in need of care and protection, that is very significant. That is one initial step which you should all learn. And also object to people including me. If I am using that term or those terms which we frequently use, or we are oriented towards its use, because we are all trained in the adult criminal justice system. Not that this Juvenile Justice Act of 2000 is an innovative or one of its kind or the first legislation in this arena, in this area. No. We have had laws. We have had laws right from the late 19th century. The Reformatory Schools Act of 1869 or 1879, I am not sure about the exact year. Then we have Boys Act.